We have three cases on the calendar this afternoon, and we'll call them in the order in which they appear on the calendar, the first one being MRH versus State. Counsel for the appellant may proceed.
May it please the court, Mose Bracey of the 2nd Judicial Circuit Office of Public Defender. We represent the 13-year-old child in this case. With me at counsel table is Steve Seliger. I would ask to reserve 5 minutes for rebuttal. A straightforward application of this court's decision in J.G. versus State is all that is required in this case. Applying that decision and ruling in the child's favor here would not extend the principles of J.G. in any fashion. Instead, it would further consistency, predictability, and uniformity of the law, because the facts here favor the child even more than in J.G. What's striking about the trial record here, as in J.G., is the absence of evidence and specific factual findings addressing the threshold issue of whether the child knowingly and intelligently waived his rights to remain silent, to have counsel, with a full understanding of those rights as well as the consequences of waiving them. The United States Supreme Court has observed that a child's age is more than a chronological fact. A child's age generates common sense conclusions that can apply to children broadly as a class.
Let me ask you this question. In J.G., there was a lot going on in that case that wasn't going on here. You have a lengthy recitation of facts, some of which overlay in this case pretty well in your favor, and some of which maybe not. J.G. is,
perhaps maybe some evidence that my client committed these crimes, but it's certainly not proof beyond a reasonable doubt. And so my argument would be that on the harmless error issue, absent my client's confession, the state could not have proven their case beyond a reasonable doubt at trial. And in fact, Judge, I would note that as part of the state's case at trial, the renter, the owner of the condo, and the investigating officer were the only three witnesses for the state. At the conclusions of the state's case, the child did move for a motion for involuntary dismissal, arguing that the state had proved the crime, but not that the child committed it, and it was denied. However, absent the child's confession, that motion would have had to have been granted. And I would note that the state points to the co-defendant's testimony as well as my client's testimony as being cumulative to the confession. However, that didn't come in until the defense case. So if nothing else, the admission of the confession was harmful in the sense that a motion for involuntary dismissal would have been granted absent the child's confession. A ruling in the child's favor here would be consistent with the increasing recognition by the U.S. Supreme Court that children cannot be viewed simply as miniature adults. Children often lack the experience, perspective, and judgment that's needed to avoid making choices detrimental to their interests.
Well, of course, we're not ruling on this initially. We're reviewing it, and that could be a fine distinction. But what, well, I don't think it is such a fine distinction, but what is the standard of review in an issue like this?
Judge, I believe the standard of review here would be de novo. I would note that the trial court's decision as to whether the child knowingly and intelligently waived his rights is a legal conclusion, and therefore it would be subject to de novo review. Obviously, any factual findings would be subject to competent substantial evidence, but I do believe that the legal conclusion here as to whether the waiver was knowing and intelligent would be de novo.
Was there any evidence in the record that I believe what happened is that the child was arrested at home where he was living with his grandfather?
Yes.
Is that it?
Yes,
is there any evidence that there was some conversation between the detaining officer or officers and the grandfather relative to, getting some permission to take the child and question him?
Yes, ma'am. Judge, the trial court did make a finding that the child had an opportunity to consult with his grandfather. And I do think that there's evidence that in a formal sense there was an opportunity insofar as they were in each other's presence and could have heard each other speak to each other. However, there's no indication that it was a meaningful opportunity in the sense that the arresting officer was standing there the whole time. There's no indication that there was any privacy. Certainly, despite the state's contention to the contrary, there's no competent substantial evidence that the child actually did converse with his father. I would also note, Judge, that there's no competent substantial evidence that the grandfather had knowledge that his grandson was being taken to the station for the purpose of an uncounseled police interrogation. And then I would also note that there's no competent substantial evidence that the grandfather actually had an opportunity to speak with his grandson about the nature of his rights and the consequences of waiving them. Finally, I would point out that the investigator did testify that he never advised the child that his grandfather could be there. So in a formal sense, there was an opportunity to consult, but there certainly was not, in terms of substance, a meaningful opportunity.
One more quick question. I know I'm into your rebuttal time.
Yes, ma'am.
Was the child read his Miranda rights at the time he was taken from home?
The state does make that contention in its answer brief, but there's no competent substantial evidence that the officer advised him of his Miranda rights on scene. The first officer who was on scene didn't testify at the hearing. The investigating officer, on the one hand, testified, I believe that the first officer advised him of his Miranda rights, but then he later clarified and said, I couldn't understand I did not hear the conversation between the first officer and the grandfather and the child. So I believe that there's only competent substantial evidence that he was read the Miranda rights once at the station. And unless there are further questions, I'll reserve the remaining time for rebuttal. Thank you.